and today we'll be looking at arbitration in cooperative societies. And under this, we'll be looking at the advantages also and the disadvantages of arbitration and why cooperative prefer arbitration. Also, who orders arbitration in cooperative. Furthermore, we also look at the application for arbitration, how to apply for arbitration, and also the authority of the arbitrator that is called to him by the Cooperative Societies Act, and how to serve arbitration notice. But first of all, let us know what is arbitration in cooperative before we proceed to all this. First, arbitration in cooperative is defined as extrajudicial mechanism through which conflict between two or more parties is resolved by impartial individual called arbitration in order to avoid costly and lengthy litigation. The cooperative being an autonomous association of persons that is jointly owned by individuals to meet their common economic needs and aspirations. At times, issues is likely to arise, and when the issues arise, they should be settled in order for the cooperative to continue doing its business. Normally, it is not uncommon for people or group of people, even nations, to disagree upon themselves in the course of their dealings with one another. So dispute can easily emanate from the way a common asset is managed or even shared. So issues may arise, problems may arise between cooperatives or between the members of the society. Maybe there might be a disagreement on some decisions on how to run the society or how profit should be appropriated. So these are the issues that will normally arise. So though the issues will arise, the cooperative must find a way to resolve those issues, because if they are not resolved, it will affect the business of the cooperative, and therefore bringing the cooperative is likely to go moribund. That is why the cooperative employ the service of arbitrators. In Nigeria, for instance, cooperative disputes are recognized in accordance with Section 49 of the Nigerian Cooperative Act. Also, when such misunderstanding and misgiving touch on the business of the registered society, such agreement may arise as a result of the following. So we are looking at now the causes or those that might be involved in a cooperative dispute that might need the services of an arbitrator, or that arbitration should be employed. The first one here is among present or past member. One of the principles of a cooperative is voluntary entry and exit. So people are allowed to join the cooperative, and they can easily go when they are tired of the cooperative or when they feel like they don't want to belong to this society again. So during the course of time, members of the society might have issues with one another. That is why we term among present or past member. So the issues may arise between the present members of that society or even past members that have already left the society. And we all know cooperatives don't go to court to settle their dispute when it involves one another. So that is the reason why we employ what we call arbitration. Later in the video, we will also talk about the advantages and disadvantages of arbitration. And the second people or disagreement that might arise in cooperative is between a present, past or deceased member and the society or any office of the society. Also, the cooperative society might be involved with the members. They might have issues pertaining to appropriation of surplus, disagreement during annual general meetings and all that. So it might be between a deceased member. Deceased member might have died. Maybe the siblings, the families of the deceased member might take up a case against the cooperative society or any officer of that particular society, and that is the reason why they employ what we call arbitration. So in cooperative arbitration is just like the cooperative court. It's just like cooperative court. So we don't go to normal court. We settle our case through arbitration. The third one is between the society and any committee of the officer. Here, the cooperative society might be called upon to settle their case between any committee officer. The committee officers, as we know, start from the president, the vice president, the secretary, the treasurer, the financial secretary, or any principal officer the cooperative might deem fit to employ. So they might have disagreement on some things. Maybe the secretary or the treasurer, there is a discrepancy with the figures being recorded and things like that. An issue might arise. So, and it might be hindering the progress of the society. That is the reason why we employ arbitration, in order to settle them, so that the cooperative business will continue to strive. Also, we have the last one here, between the society and any other registered society. It might be between farmers cooperative society, or between producers cooperative society, and just different cooperative societies. This is the issue that need to be settled between them. And you know, cooperative, they can't go to court. Yes, the normal court can't settle cases between cooperative because, one, they don't have knowledge about how the cooperative works. They don't understand our principles, our norms, our ethics and values. That is the reason why we will not settle our case in court. So that being said, a registered society can be having issues. Maybe they did business together and that's an issue. So they can employ the services of an arbitrator. So next up, in the next video, we'll be looking at the disadvantages or the merit and merit of arbitration in cooperative. Don't forget to subscribe, share the video.